What you are about to hear is not just another tense exchange in a Senate hearing room. It is one of the most brazen, jaw-tightening confrontations between a United States senator and a sitting attorney general in recent memory, and it begins with a number that refuses to disappear. That number is $50,000, allegedly handed over in cash, reportedly delivered in a paper bag, to Tom Homan, a senior Trump immigration official. Not a wire transfer, not a treasury check, not a documented reimbursement processed through federal accounting channels, but cash in a bag. And Senator Sheldon Whitehouse walked into that chamber determined to force clarity where there had only been smoke.
What became of the $50,000? Did the FBI get it back?
Mr. Whitehouse, Senator Whitehouse, you're welcome to talk to the FBI.
The report to you, can't you answer this question?
Senator Whitehouse, you're welcome to discuss this with Director Patel.
Did Homan keep the $50,000?
As Deputy Attorney General Todd Blanche recently stated, the investigation of Mr.
Never
Homan
mind. I can see I'm not going to get a straight answer from you to a very simple question.
He did not come to perform. He did not come to grandstand for cable news clips. He came armed with specific questions, precise wording, and the prosecutorial patience of a former United States attorney who understands that truth is often revealed not by dramatic speeches, but by repetition. He aimed every single question directly at Attorney General Pam Bondi, and he asked one simple thing: what happened to the money? That is not a partisan question. That is not a trick question. That is the most basic accountability inquiry imaginable. What became of the $50,000 in cash that the FBI delivered to Mr. Homan? Did he keep it? Did the FBI retrieve it? If he kept it, did he declare it on his tax returns? Those are questions that any competent agency head should be able to answer without hesitation. Yet what followed was not clarity, not transparency, not even partial explanation, but evasion so mechanical and rehearsed that it felt less like testimony and more like a script being recited under duress. Pam Bondi did not say the money was returned. She did not say Homan did not retain it. She did not say the transaction was logged and reconciled. Instead, she invoked Deputy Attorney General Todd Blanche and repeated a line about no credible evidence of wrongdoing having been found. That phrase became her shield, her refuge, her escape hatch. Whitehouse asked again, deliberately narrowing the question. What became of the $50,000? Again, Pam Bondi cited Blanche and the absence of credible evidence. That was not the question. Whitehouse said so explicitly. He was not asking whether wrongdoing had been established. He was asking about the physical disposition of cash. Did the FBI get it back? Did Mr. Homan keep it? That distinction matters because accountability is not an abstract concept. It is transactional. Money moves. Records exist. Taxes are filed. A Justice Department that cannot answer where cash ended up is not a Justice Department functioning normally. Pam Bondi responded by telling the senator to look at his facts. She asked whether he was saying the money had not been delivered. But that maneuver did not answer the underlying issue. Whitehouse pressed again, this time sharper. Did Homan keep the money? She repeated the Blanche review language again, unchanged, unvaried, almost defiant in its repetition. At that moment, the hearing shifted from oversight to exposure. Whitehouse understood what was happening. He stated plainly that he was not going to get a straight answer, and that admission did not weaken his position. It strengthened it. Because when a senior lawmaker publicly acknowledges that the nation's chief law enforcement officer refuses to answer a direct factual question, the refusal itself becomes evidence. Evidence of what, precisely, is what the senator was building toward. Pam Bondi then pivoted. She accused Whitehouse of being concerned about money while working with party groups. She suggested hypocrisy. She attempted to shift the focus from a paper bag of cash to political funding. This is the classic deflection. Attack the questioner rather than the question. But the question did not disappear. It hung there, unresolved, heavier with each evasion. Whitehouse escalated with surgical precision. He asked whether, during the investigation, anyone examined whether the 2024 $50,000 payment was declared on Homan's tax returns. That is not rhetorical flourish. That is a compliance inquiry. That is how prosecutors think. If someone receives cash and the cash is retained, tax law is implicated. Pam Bondi did not answer that either. Instead, she insinuated that Whitehouse should be concerned about corruption in his own orbit, referencing legislation and his wife's company. That was not just deflection, it was personal attack. It was an attempt to muddy the water so thoroughly that the original subject might drown in the chaos. But chaos does not erase the fact that a United States senator had asked 5 times about $50,000 in cash and received 0 factual answers. Whitehouse called out the irrelevance of her remarks directly. He described them as far-right internet talking points. He was not whispering. He was not hedging. He was identifying the tactic in real time. When oversight becomes inconvenient, introduce noise. Introduce insinuation. Introduce unrelated controversies. Anything but the ledger entry that says where the money went. The larger implication began to crystallize. If the Attorney General cannot state whether the FBI retrieved cash it delivered, then either she does not know or she will not say. Both possibilities are alarming. A Justice Department head who lacks knowledge of such a matter suggests institutional breakdown. A Justice Department head who knows but refuses to disclose suggests institutional protectionism. Whitehouse did not let the institutional thread drop. He tied Homan's situation to broader concerns, referencing alleged conversations involving Eric Adams and talk of agreements. He was constructing context, not as gossip, but as pattern. The $50,000 was not floating in isolation. It existed within a network of relationships and transactions that deserved scrutiny rather than dismissal. Pam Bondi continued to cite the Blanche Review as though repetition could substitute for substance. But Todd Blanche, as Whitehouse well knew, is not a neutral arbiter in the public imagination. He is Trump's former defense attorney, now serving as Deputy Attorney General. That fact does not itself establish misconduct, but it complicates credibility. When the only answer offered is that the loyal deputy found no wrongdoing, skepticism is rational. This was not grandstanding. This was prosecutorial method. Ask the question. Clarify the question, narrow the question, force the witness to confront the literal wording. Each refusal sharpened the contrast between inquiry and evasion. Each deflection amplified the sense that something basic was being withheld. The hearing room did not erupt. There were no shouting matches. What made the exchange chilling was its steadiness. Whitehouse remained focused on the same simple factual inquiry. Pam Bondi remained fixed on avoiding it. In that tension lay the real story. Not the theatrics, but the vacuum where an answer should have been. And the vacuum speaks. It suggests that in this administration, loyalty may outrank transparency. It suggests that when cash changes hands under murky circumstances, the instinct is not to clarify but to shield. It suggests that the Department of Justice may be operating less as an impartial guardian of law and more as a barrier between sensitive facts and public scrutiny. The $50,000 remained unaccounted for at the end of that sequence. The paper bag image lingered. The repeated invocation of no credible evidence did not resolve the underlying question. It simply postponed it. Whitehouse had laid the foundation. He had demonstrated that the Attorney General would not answer the simplest of accounting questions, and that foundation would become the platform for everything that followed. That foundation did not sit quietly in the background. It expanded, it widened. It began to connect to other threads that made the refusal to answer about $50,000 feel less like a minor omission and more like the first visible crack in a much larger structure. Whitehouse understood that a single unexplained transaction might be dismissed as confusion, but a pattern of silence across multiple related issues begins to look like something else entirely. So he did what experienced prosecutors do when they sense resistance. He moved from the isolated fact to the surrounding ecosystem. He reminded the room that Tom Homan was not some anonymous bureaucrat lost in the machinery of government. He was a high-profile Trump immigration official with influence, with access, with proximity to power. And when someone that close to the center of executive authority receives $50,000 in cash from the FBI, the burden of clarity is not optional. It is absolute. The refusal to provide that clarity becomes its own form of testimony. Whitehouse sharpened the lens by tying the money question to the alleged exchange involving Eric Adams, in which Homan reportedly referenced an agreement and suggested he would return to Adams's office demanding compliance. That remark, on its face, raised the specter of leverage, of quid pro quo dynamics that deserve scrutiny rather than dismissal. The senator was not alleging guilt in the abstract. He was drawing lines between events that share participants and timing. And still, the $50,000 sat there, unresolved, a concrete number in a hearing that was otherwise drowning in generalities. When Whitehouse asked whether the FBI retrieved the money, Pam Bondi again deflected to Todd Blanche's review and the absence of credible evidence of wrongdoing. But credible evidence of wrongdoing is not the same thing as an accounting record, and that distinction matters profoundly. The Department of Justice is not merely an adjudicator of criminal guilt, it is a custodian of procedure. The senator then pivoted to what any competent financial investigator would ask next. If the money was retained, was it declared on Mr. Homan's tax returns? That question is not accusatory by default, it is procedural. The Internal Revenue Code does not bend around political loyalty. Income is income. Cash is income if kept. And the failure to answer whether such a declaration was examined compounds the opacity. Pam Bondi did not engage the tax angle substantively. Instead, she turned again to Whitehouse's associations, insinuating hypocrisy, raising his wife's company, implying legislative favoritism. It was a textbook shift from scrutiny of a specific transaction to insinuation about character. But character attacks do not reconcile bank records, and they do not answer whether $50,000 was logged, taxed, or returned. The atmosphere in the chamber was not explosive. It was colder than that. It was the kind of cold that settles when people recognize that an institutional safeguard is malfunctioning. Whitehouse was not shouting. He was methodical. And Pam Bondi was not engaging the substance. She was circling the perimeter, refusing to step into the center of the question. Then came the Office of Professional Responsibility. Whitehouse moved to the reported OPR investigation into alleged prosecutorial misconduct involving Amel Bowe, who at the time of the relevant events was a Department of Justice employee. OPR exists for one reason: to investigate misconduct by federal prosecutors. It is the internal conscience of the department. If OPR had investigated issues connected to the same transaction involving Homan, that fact would be significant. Whitehouse asked directly what became of the OPR investigation. Pam Bondi corrected his reference to Bowe by emphasizing his later judicial title, but that semantic correction did not address the inquiry. At the time of the alleged misconduct, he was a DOJ employee. That is what made OPR jurisdiction relevant. The senator asked whether OPR had issued a public summary, as is customary when investigations conclude. Pam Bondi refused to confirm whether an OPR investigation existed, citing pending litigation and personnel matters. But OPR routinely publishes summaries of completed investigations without violating confidentiality. Whitehouse was not demanding confidential memos. He was asking whether a standard oversight mechanism had operated and whether its conclusions had been made public. That refusal to even acknowledge the status of the investigation deepened the perception of institutional defensiveness. The pattern was unmistakable. On the $50,000, no answer. On the tax declaration question, no answer. On the OPR investigation status, no answer. Each time the explanation was couched in legal caution, but the cumulative effect was not caution, it was concealment. A department confident in its processes does not fear acknowledging their existence. Whitehouse then shifted to Kash Patel's grand jury testimony. Patel had told the committee that after initially pleading the Fifth, he testified under immunity and that his testimony was sealed by the Department of Justice. That is not an insignificant procedural fact. The sealing of grand jury testimony is governed by specific rules and justifications. Whitehouse asked how and when the testimony was sealed, by whom and why. Pam Bondi refused to discuss whether the testimony was sealed. Not the content, not the details, but even the basic procedural status. The senator pressed, was it sealed or not? Again, she declined. This was not a request for confidential evidence. It was a question about the department's own actions regarding sealing. That information, if purely procedural, should not have required evasion. The contradiction sharpened when Whitehouse pointed out that Patel himself had testified that he worked with the Department of Justice to have his transcript released publicly. If the transcript was released publicly, then discussing its release would not violate secrecy. Pam Bondi referred the question to Director Patel, even though the question concerned the Department of Justice's decision-making process. That deferral was more than rhetorical. It suggested an abdication of ownership. If the department sealed testimony and then participated in releasing it, the Attorney General should know the circumstances. Referring the inquiry to someone outside her chain of command undercut the coherence of executive responsibility. It created the impression of fragmentation at the top of American law enforcement. Whitehouse was not improvising. He was building a record. Each unanswered question was not just a moment in a hearing, it was a data point in a broader narrative of resistance to oversight. The senator was constructing a map of institutional opacity, and Pam Bondi's refusals were marking the boundaries of that map in bold ink. The prosecutorial tone intensified not through volume, but through persistence. Whitehouse was demonstrating that the issues were interconnected. The unexplained cash, the alleged agreements, the OPR inquiry, the sealed testimony. None of these stood alone. Together they formed a pattern of evasion that could not be dismissed as coincidence. And what made the exchange so stark was the simplicity of the questions. Where did the money go? Was it declared? Did OPR investigate? Was the testimony sealed? These are not abstract philosophical debates. They are binary inquiries about actions taken or not taken. When those cannot be answered, the silence itself becomes the most eloquent statement in the room. By the end of this segment of the hearing, the atmosphere had shifted decisively. It was no longer about a single disputed transaction. It was about whether the Department of Justice under Pam Bondi was prepared to answer Congress in good faith. And on that day, with those questions, the answer to that larger question seemed to be no. And just when the pattern of evasion seemed fully exposed, Whitehouse pivoted to an issue that carried even greater political and moral weight: the Jeffrey Epstein files and the suspicious activity reports that Treasury automatically forwards to the Department of Justice. This was not a speculative dive into internet rumor. This was a targeted inquiry into official government documents known as SARs, suspicious activity reports, that are generated by financial institutions and flagged when transactions raise red flags under federal anti-money laundering statutes. Hundreds of such reports were tied to accounts connected to Jeffrey Epstein. Whitehouse asked the most basic oversight question imaginable. How many of those Treasury SARs did you or Director Patel investigate? That is not an accusation. That is a metrics question. In any serious investigation involving financial crimes, SARs are foundational. They are often the starting point for tracing networks of payments, transfers, shell accounts, and potential co-conspirators. If hundreds of SARs exist, reviewing them is not optional. It is the minimum threshold of due diligence. Pam Bondi did not provide a number. She did not say all of them were reviewed. She did not say some were reviewed. She did not say none were reviewed. Instead, she pivoted again to the personal, suggesting that Whitehouse had taken money from Reid Hoffman, who she attempted to link to Epstein. The deflection was immediate and unmistakable. Rather than address whether the department had examined the suspicious activity reports, She attacked the questioner's associations. That tactic might play well in partisan media spaces, but inside a Senate oversight hearing it rang hollow. The existence of SARs is not partisan. The Treasury Department generates them regardless of who sits in the White House. The question was not whether Whitehouse had ever received political donations. The question was whether the Department of Justice had examined official financial red flags tied to one of the most notorious criminal cases in recent American history. Whitehouse did not allow the deflection to stand unchallenged. He pointed out that these were official reports, labeled suspicious by design. The implication was clear. If you inherit hundreds of suspicious activity reports connected to Epstein accounts and you review 0 of them, that is not an oversight gap. That is a decision. And decisions at that level reverberate far beyond a single case. The tension escalated when Whitehouse referenced public reporting that Epstein had shown people photographs of President Donald Trump with half-naked young women. He did not assert the truth of those reports as established fact. He asked a narrower law enforcement question. When the FBI searched Epstein's safe, his premises, his properties, did they find such photographs? That question is about evidence inventory, not political commentary. Pam Bondi responded by accusing Whitehouse of making salacious remarks and attempting to slander President Trump. But the senator's question was not whether Trump had committed wrongdoing. It was whether the FBI had found physical evidence described in sworn or named witness accounts. That distinction matters profoundly. Oversight is about what the government found and what it did with what it found. Instead of answering whether such photographs were discovered, Pam Bondi returned to Reid Hoffman and political donations, broadening the attack to other senators and past votes. It was a strategy of saturation. Flood the field with unrelated allegations so that the original question dissolves. But it did not dissolve. It remained stark and unanswered. Did the FBI find the photographs? This was the moment when the prosecutorial tone of Whitehouse's line of questioning revealed its full force. He was not interested in rhetorical jousting. He was constructing a record of non-response. The question about the photographs was not isolated from the SRs. If suspicious activity reports tied to Epstein accounts had been inadequately reviewed, and if potential evidence involving high-profile individuals had not been transparently accounted for, then the integrity of the investigation itself comes into question. Pam Bondi's refusal to address the evidence question reinforced the perception that the department's posture was defensive rather than transparent. A confident administration would say clearly whether the FBI located such materials and what their evidentiary status was. Instead, the room heard personal counterattacks and insinuations. The silence around the evidence grew louder. Whitehouse's line of inquiry illuminated something deeper than a single case file. It suggested that under this leadership, the Department of Justice was less concerned with exhaustive review and more concerned with shielding political allies from uncomfortable scrutiny. When oversight questions about evidence are met with character attacks, the institution begins to look less like a guardian of law and more like a fortress protecting power. The Epstein SARs were not minor paperwork. They represented documented financial anomalies flagged by the banking system. They carried implications of broader networks, potential facilitators, and systemic failures. Ignoring them or declining to explain how they were handled sends a message. It signals that certain threads are not to be pulled, certain doors not to be opened. The photograph question carried symbolic weight because it touched on proximity between Epstein and powerful figures. If such images existed and were found, their existence would be a matter of record. If they did not exist, that too could be stated plainly. The refusal to answer either way did not neutralize the issue. It intensified it. It suggested that even acknowledging the status of evidence was politically sensitive. Throughout this segment, Whitehouse remained consistent in tone. He did not escalate into shouting. He did not abandon specificity. He asked, he clarified, he repeated. The prosecutorial cadence was deliberate. Each unanswered question was logged implicitly in the public record. Each deflection became part of the narrative he was building. Pam Bondi's approach remained consistent as well. Redirect. Attack. Invoke unrelated associations. Cite loyalty figures within the department. Avoid the binary. The clash between those two strategies defined the hearing. It was not about theatrics. It was about whether the Department of Justice would engage Congress with candor or retreat behind political armor. By the end of this third movement, the scope of the inquiry had expanded dramatically from a paper bag of cash to the handling of one of the most consequential criminal investigations in recent history. The common thread was accountability. What happened to the money? What happened to the suspicious activity reports? What happened to the evidence inventory? What happened to transparency? And the common response was silence, dressed up as deflection. The Attorney General of the United States had been given multiple opportunities to clarify the department's actions. Instead, she chose to challenge the motives of the questioner. In doing so, she transformed oversight into confrontation, and she revealed a posture that many observers would interpret as protection rather than prosecution. And as if the unanswered questions about cash, sealed testimony, suspicious activity reports, and potential evidence were not enough, Whitehouse pivoted to something that strikes at the very heart of constitutional order: the safety of federal judges and the possibility that threats against them are being orchestrated rather than random. This was not a partisan skirmish. This was about the integrity of the judiciary, about whether judges who rule on cases involving powerful interests are being targeted in coordinated campaigns of intimidation. Whitehouse asked whether the United States Marshals Service, which is tasked with protecting federal judges, is being allowed to investigate not just the individuals who make threats, but the potential orchestration behind those threats. That distinction is critical. A single person sending a message is one thing. A network coordinating harassment, doxing, and death threats is another entirely. And if such orchestration exists, federal conspiracy statutes, racketeering laws, and aiding and abetting provisions are implicated. Pam Bondi's initial instinct was not to answer directly. She glanced to the chairman, as if seeking procedural escape. The time was nearly expired. The moment could have ended there. But Whitehouse had already begun the question within his allotted time, and the convention of the committee allowed for an answer. That procedural detail mattered, because it underscored the tension between answering and avoiding. When Pam Bondi finally responded, she offered to sit down with Whitehouse and discuss threats to federal judges, to set up a meeting with the director of the Marshals Service, to take threats seriously. The language was conciliatory, but it did not directly address whether the marshals are investigating orchestration. It did not confirm whether coordinated campaigns are being probed under conspiracy statutes. It promised conversation, not clarity. And that promise came only after visible hesitation. That hesitation was telling. Because if the Marshals Service is actively investigating orchestration of threats, the Attorney General could have said so plainly. If they are not investigating such orchestration, that too could have been stated. Instead, the answer was wrapped in procedural courtesy, deferring the substance to a future meeting behind closed doors. Whitehouse's line of questioning had now traveled from a paper bag of cash to the safety of judges. That arc was not accidental. It was strategic. It was about demonstrating that the same instinct to evade transparency on financial and evidentiary matters extends to issues of judicial protection. When oversight encounters resistance across multiple domains, it suggests a pattern rather than an anomaly. Throughout the hearing, Pam Bondi had repeatedly referred questions to others, to Todd Blanche, to Director Patel, to unnamed prosecutors. She had invoked pending litigation and personnel matters. She had attacked Whitehouse's associations. But in none of these exchanges did she provide straightforward factual clarity on the central issues raised. The cumulative effect was not ambiguity. It was opacity. Whitehouse had done what senators are constitutionally empowered to do. He asked specific questions about specific government actions. He requested basic information about transactions, investigations, evidence, and institutional responses. He did not demand confidential sources. He did not ask for classified details. He asked for the status of money, the review of suspicious reports, the sealing of testimony, the existence of investigations, and the scope of judicial protection efforts. And on each of those points, Pam Bondi declined to answer in direct terms. That refusal is not a small procedural hiccup. It goes to the core of the separation of powers. Congress has oversight authority precisely so that executive agencies cannot operate as closed systems insulated from scrutiny. When the head of the Department of Justice refuses to engage substantively with oversight questions, it weakens that constitutional balance. The $50,000 remained unaccounted for in public testimony. No confirmation of return, no confirmation of retention, no confirmation of tax declaration review. The OPR investigation status remained undisclosed. The sealed grand jury testimony remained shrouded. The suspicious activity reports remained unquantified in terms of review. The existence of photographs reportedly described by witnesses remained unaddressed, and the scope of Marshall's investigations into orchestrated threats remained vague. This was not a single missed answer. It was a cascade of refusals. Each refusal reinforced the next. Each deflection amplified the perception that transparency was being rationed, not offered. And that perception matters because public confidence in the justice system depends not only on outcomes, but on openness. Pam Bondi's defenders might argue that caution is prudent, that ongoing matters require discretion. But discretion does not preclude acknowledging the existence of procedures. It does not prevent confirming whether money was retrieved. It does not bar stating whether SARs were reviewed. It does not forbid explaining the procedural status of grand jury sealing. Silence on such matters appears less like caution and more like containment. Whitehouse's prosecutorial style was not about spectacle. It was about accumulation. By the end of the hearing, he had accumulated a record of unanswered questions that painted a stark picture. A Department of Justice that cannot or will not clarify basic facts appears defensive. A department that responds to oversight with personal attacks appears politicized. A department that deflects evidence inquiries appears protective of power rather than protective of law. The implications extend beyond partisan divides. Whether one supports or opposes the administration, the structural issue remains the same. The Attorney General occupies a role designed to transcend personal loyalty. The office exists to enforce the law impartially, to answer to Congress when called, to provide clarity when public trust is at stake. When that clarity is withheld repeatedly, trust erodes. The hearing did not end with a dramatic confession or a smoking gun. It ended with tension unresolved. The questions remained suspended in the air. And sometimes that is more revealing than any explosive revelation. Because when straightforward inquiries produce only evasions, the absence of answers becomes the story. Whitehouse walked into that chamber with a list of questions. He left having demonstrated that those questions could not be dismissed as trivial. They touched on financial accountability, prosecutorial oversight, evidentiary transparency, and judicial protection. They were foundational questions about how power is exercised and monitored. Pam Bondi walked out having preserved loyalty lines and deflected scrutiny, but at the cost of appearing unwilling to engage substantively with oversight. Whether that posture was strategic, political, or defensive, it left an unmistakable impression. In a system built on checks and balances, the refusal to answer is not neutral. It tilts the balance. And that tilt is what this hearing ultimately exposed. Not a single isolated controversy, but a pattern of guardedness at the highest levels of law enforcement. A pattern in which questions about money, about evidence, about internal investigations, about threats to judges, are met not with illumination, but with resistance. The Constitution does not grant Congress oversight authority as a courtesy. It grants it as a safeguard. On that day, in that hearing room, that safeguard was tested. And the record now reflects not clarity, but a series of evasions that will linger long after the microphones were turned off.